All right, good morning, class. Oh, it's afternoon already. So why is your mind not here? I said good morning. You said good morning. You ought to have said good afternoon. So I hope we are fine. Okay, so for today's class, we shall be looking at the topic in continuation of the topics under classification of courts, which also is uh, with the major heading structure of court system in Nigeria. And the classification we'll be looking at this afternoon is courts of limited and unlimited jurisdiction. You recall that we've treated superior and inferior court, right? And we have also treated courts of records and courts other than courts of records. Now, something we had a public lecture yesterday at the Faculty of Law, and the Chief Justice of Nigeria was here yesterday, and at the same time, the Chief Judge of Lagos State was also present. And when the Chief Judge of Lagos State was addressing us, he said something about courts of records, which also further established a point to me, and I said I was going to share with you for the purpose of this class. Now, you will recall that there was a time we had EndSARS in this country, right? And it led to a lot of destruction of various places. And the High Court of Lagos State, Igbohere, was not an exception. And then all the file, majority of the file, or a large part of it, were destroyed by Ifeno. And the problem it created was that litigants, that is the parties, could not immediately start up their cases where they ended. Why? Because the court is bound by its record. Whenever there's a case, if there's a case between this lady and this man, they will have their own file, right, containing all their paperwork, and the judge, who is the court, will also have their own file. Now, these two parties are bound by what is in the court's file. For example, if Mrs. A is claiming that I have filed a particular process and I've even served Mr. B, who is the opponent, are you getting me now? And the court is saying that that process you said you have filed and served the other party is not in the court's file. That is the end. Meaning that the court is not aware of what you have filed. So the copy belonging to the court, some of them were destroyed in the course of that fire incident. And the chief judge was trying to explain that it created a lot of problem for the judiciary, in that they needed to start looking for how to make up the court's copy or the court's file so that litigants can continue from where they stop. And he emphasized that the High Court of Lagos, being a court of records, ought to sustain that record keeping, because the records of courts may be needed tomorrow for either a review, like we said in the course of the class, to review the cases, or even for maybe an appeal, or for whatever purpose that is required. Because the topic of the public lecture has to do with the practice of law and artificial intelligence, IT, how documents can be stored, and so on and so forth. So the High Court is one of the courts of record because the record of their proceedings are mandatorily expected to be kept for whatever need that may be required of it, flowing from review, appeal, or even for sometimes may even be for academic purposes or whichever is the case. So that is, that's the gist I just got in the course of that talk, and I said I will share with you. So this afternoon, like I said, the topic will be courts of limited and unlimited jurisdiction. And then the question we need to start with is, what is jurisdiction? What is jurisdiction? So the word jurisdiction is what we then need to determine what is, and then we can now start to understand what we mean by courts of limited and unlimited jurisdiction. Now, the word jurisdiction is from Latin. From Latin means law, or juris means law. Okay? Juris means what? Law. Why dictio, as in dictio, means speech or declaration. So I said the word jurisdiction from Latin, if we are to understand its meaning, the law part of it, in law, juris means law, and then dictio means speech or declaration. But this, when you relate it to legal position, like we are having in this class, the term means legal authority. That is to say that jurisdiction means what? Legal authority. And that is the authority that a court of law has to entertain a particular subject matter. You will recall some time back we talked about the various subject matter that a court can attend to, right? We talked about court can attend to issues pertaining to family, issues pertaining to land matters, issues pertaining to chieftaincy title, and several other subjects, to even include commerce or economic issues. So we're talking about a legal authority. So simply put, jurisdiction is used to describe the legal authority granted to a legal entity to enact justice. Okay? Is the term for legal authority granted to a legal entity to enact justice. Now, by virtue of Section 6 of the Constitution of the Federal Republic of Nigeria, the court of law in Nigeria is vested with power of the judicial power of the states. And that's why if there is a dispute between the federal government and the state government, and you submit it to the court of law, whatever the decision that the court of law gives is what the federal government will abide by. And that speaks of the authority of the court. We've had cases where a military government in Nigeria at a time had a case with Ojukwu, and the court gave a judgment. And parties will have to obey what the court says, because just as the executive power is vested in the executive led by the president, which nobody can tamper with except where the power is being exercised in a way that is contrary to the provision of the law. That's when there can be either a court proceeding to stop the president, or for the legislative arm to intervene by making such action to become null and void. But as far as it is legal, so be it. Look at all the noise that you made when state of emergency was declared in Rivers State. What has our noise done? For example, the president declaration stands because in the eye of the law as it stands today, the action is valid. So the same thing applies to the courts. Once a court has a jurisdiction, that is the legal authority to handle or to entertain a matter, that court is vested with judicial authority and power. And whatever the court says is what, we hold at the end of the day. So, when we're talking about jurisdiction, like in the case of Nigeria, jurisdiction applies to multiple levels. Okay? I said jurisdiction does what? Apply to multiple levels, to include the local government, the local, the state, and the federal. So, meaning that to further understand, the authority vested in the local government is also the jurisdiction that it possesses. The authority that is vested in the local government is the power that the local government has. The local government has power or possesses power to collect rates from market people. And that's why for those of you who do trade at Ojuwoye market or which other markets, government officials, local government officials come to do what? Why are you behaving as if they don't come to you? They don't call, you don't trade. Many of you are business people, I know. When you are just doing tech, but out there you do your business. Okay, you will see them come to collect. And even the craziest, permit me to use the word, the craziest of the market woman will not say that she will not pay. Why? Because the local government is vested with the power to collect such rates. But the power of the local government is limited to the point of such authority that have been given to them. They cannot collect taxes from companies that are duly registered in Nigeria. Why? Because they do not have the legal authority to do so. They've taken over this thing, it's not working, and it's working somewhere. All right, so again, it can also mean the authority by which a judicial officer take cognizance of and decide causes. Jurisdiction can also mean the authority by which judicial officers take cognizance of and decide causes. Causes as in CAUSES. That's what we call cases. The word you call cases in normal parlance. In law we call it causes. Okay? So I said the authority by which judicial officers take cognizance of and decide causes. Causes as in CAUSES. So now another author also defined what jurisdiction is all about. The author said Jurisdiction is a right by which judges exercise their power. Jurisdiction is the right by which judges exercise their powers. So, meaning that from all that we have been saying, jurisdiction talked about the power that a court of law has to entertain all the matter that is placed before it and do justice. Meaning that the court of law has a duty to do justice in whatever cause that is brought before it. So now let's move forward to look at the types of jurisdiction. Types of jurisdiction. This will give us an understanding of the topic that we are looking at, which is courts of limited and unlimited jurisdiction. Number one is original jurisdiction. What did I say? Number two is concurrent jurisdiction. Concurrent jurisdiction. And the third is appellate jurisdiction. Appellate, from the word appeal. I will spell for the purpose of clarity. A-P-E-L-L-A-T-E. Appellate jurisdiction. So we have three types of jurisdiction. Can you name them? Yes? All right. So what is original jurisdiction? Therefore, original jurisdiction grants authority of a court to hear a case for the first time. Original jurisdiction grants authority to a court, or talks about the authority of a court to hear a matter for the first time. Even though we're not law students, but you will recall that we have talked about the different subject matters that can be taken to court, right? Let's take, for example, a divorce case. A divorce case has a particular court that he must go to. It must go to the High Court and not Magistrate Court. So to the High Court, that kind of a proceeding, the jurisdiction is vested in who? In the High Court. Meaning that the High Court has the original jurisdiction in that matter. You cannot take it to Court of Appeal. Neither can you take it to where? The Supreme Court. So you can't take that case to a magistrate court. By now you know that the magistrate court forms part of the inferior courts, and of course in the ladder is lower than the High Court. So that authority that a court of law has to hear a matter first is what is referred to as what? Original jurisdiction. The High Court has a set of cases that it can hear at first. The same thing for Court of Appeal. The same thing for what? For the Supreme Court. All of them, they have their what? Their original jurisdiction. But generally speaking, when we talk about original jurisdiction, we talked about the authority of a court to hear a case for the first time. Now, number two, concurrent jurisdiction. Concurrent jurisdiction may be exercised by two or more courts over the same matter. I said concurrent jurisdiction speaks of a jurisdiction where a court of law or two or more courts may exercise their powers over a particular cause or matter. Is a cause that is creating the issue. I've told you before that what you call cases, you say you have a case in court, right? We lawyers don't say we have a case in court. We say we have a matter. And the court also refers to matter or case as a cause, not the cause that is coming to your mind now, but the CAUSES. Okay? So, concurrent jurisdiction grants the power, or the jurisdiction may be exercised by two or more courts over the same matter. Meaning that, okay, can you recall which issues or matters can the federal government legislate on and also the state government? Where are the, okay, the political science students are not here. Okay. Now we have what we have the in the constitution we have exclusive list. You know it. Followed by what? And what? So in the concurrent, what are the items in the concurrent list? Just give me one. Give me one. What? Education. Meaning that federal government can make laws about what? So also with states. Why is it so? Because we have, for example, we have federal institutions like the University of Lagos where you are. We also have what? States. And the issue of education is something that, of course, pertains to these tiers of government. So, issues of, okay, give me one example of issues or items under exclusive list. Currency. Defense. Aviation. Now, the state government does not have powers to make law on issues pertaining to currency. Why? Because it's what? It is in the exclusive list. We can say, for the purpose of understanding what we are saying, that is the original jurisdiction of what? Of the federal government. Why education, which falls between what the two of them can, comes between or into the what? Concurrent list. And that is the concurrent jurisdiction that we are talking about. So we can say categorically that the federal government and state government has concurrent jurisdiction on issue of education in Nigeria, meaning that they have power to do what? To make policies, laws regarding education. I think that is very clear. The third one is appellate jurisdiction. So take your mind off from concurrent list, executive list, because if you apply that one to this appellate jurisdiction, you will be lost. Okay, now, this is a jurisdiction that allows a court to hear a case that has already been decided on in a lower court. The appellate jurisdiction is the jurisdiction that allows a court of law to hear a matter that has been decided or already decided on in a lower court. It also means a situation in which a superior court is invested with the legal power to correct, if it so decides, legal errors made in a lower court. I'll repeat that again for emphasis. It also means a situation in which a superior court is invested with legal power to correct, if it so decides, legal errors made in a lower court. Now, one of the reasons for appellate jurisdiction is the possibility of errors in the judgment of a court of original jurisdiction. You know, the courts, they are also human beings, right? And human beings are prone to what? To make mistakes. Is there anybody here who has not made a mistake before? Nobody. So courts too can commit error. So from what I've given you so far, it is appellate jurisdiction is that power vested in a court to either review a case that has already been decided on. You know, ordinarily, the decision of courts is it's supposed to be final, right? But the judicial system also envisages positions where parties may not be satisfied. And to that extent, the law has provided for the appellate court, which exercises which jurisdiction now? Appellate jurisdiction. To hear such matters, review it, and then decide. And if after the review and the decision, the individual is not satisfied, he can also still further appeal to where? To another higher court. He can continue to appeal like that until he gets to where? The Supreme Court. And when he's not satisfied with the decision of the Supreme Court, he can go to where? He can go to God. But in our judicial structure, God is not put there because I think it's too big to be burdened with such things, right? That's why probably is not there. But what we are saying is that the Supreme Court is the highest court. So whatever the decision is at that point is what? Is final. So with that, I believe that we understand clearly what we mean by appellate jurisdiction. So typically, I noted here that the Supreme Court has appellate jurisdiction over cases, as most cases that come before the Supreme Court have already been decided in lower courts. In fact, let's say 90% or 99%. However, there are some instances that allow the Supreme Court original jurisdiction, mostly when the conflicts coming before the court involves two or more states. Do we get the message now? That there are some situations where Supreme Court we can also exercise original jurisdiction. You know what we mean by original jurisdiction, don't you? But what we have said generally is that the Supreme Court is more of an appellate court because it receives appeals from where? The lower court. But we are saying that there are cases where it just has to start from the Supreme Court. Examples are cases that are between state and what? And states. Take for example, Oyo State. Madam here is Lagos State. And we are dragging land. We use our popular language. And then you now bring the case to Lagos court or to Oyo court. What will happen? What is likely to happen? Don't let me say what will happen. Or you are fighting with somebody and you now fight the case to your mommy. Who do you think the mother will support? The other person, Abi? Yes, I understand where you are coming from. That some mothers will first of all give that their child a slap. You know why it's like that? They believe that on a normal day you are not even supposed to what? To fight. And so when some people said that their mother will fight the other one, I can understand. It's part of, I think it's particular with Yoruba, whatever. I know. They will first of all give you slap for that person before they now decide the case. But you know, mothers can be very emotional sometimes. Whether the child has done wrong, they will now give you that Yoruba proverb that say ọmọ ẹni ò ń ṣèdí bẹ̀bẹ̀ rẹ̀. If you have is it bead now, you want to put it in somebody's waist, and there are two people, and your child has presented herself, you will now go and carry it and give to another person. Then they do it like that. But in some cases, for justice sake, one can go against such rules, but that's the balance, just by the Yoruba people. So there is likelihood that the Oyo court will rule in favor of Oyo, which is customary. If the governor is the one paying the executive is the one paying my salary, and I'm a judge, and you bring a matter between Lagos and I will look for a way to say in Oyo state that we win now. Because if you rule otherwise, your alert may not come when it is time. So that's just on the lighter note. But for purposes of achieving justice, state courts may not be able to adjudicate on matters between two states. Even if you say, let another state come and judge in that way. If Oyo State is a friend to River State, depending on who the governor is per time, and the friendship will also play out. He will likely rule in favor of his friend, isn't it? But the Supreme Court is a neutral ground. That's why in cases pertaining to two states, the original jurisdiction, the Supreme Court can exercise original jurisdiction to hear it from that height. So that is what we mean by those different types that we have talked about. Now let me make this point that jurisdiction defines the limit of a court's authority. Jurisdiction defines the limits of a court's authority and determines whether a case falls within its purview. Jurisdiction defines the limits of a court's authority and determines whether a case falls within its purview. So therefore, there are two types of courts under this classification. Okay? So, from all that we have been saying, like I said lastly, that jurisdiction defines the limit of a court's authority and determine whether a case falls within its what? Is the purview that you do not know how to spell, that you are making noise. I know. I know your style. Some of you say, come again. Where did I go that you are coming again? And if I look at your book now, some people will have spelled purview as P-double-R. Even so, if you try to pronounce it Paul, you don't know the spelling, you don't know. Okay, the spelling is P-U-R-V-I-E-W. Purview. Where are the phoneticians in the class? How do you pronounce it? Purview. Purview, and you could not spell it. Alright. So, if you're saying that jurisdiction defines the limits of a court's authority and determines whether a case falls within its purview, Therefore, there are two types of court under this classification, known as court of limited jurisdiction and courts of unlimited jurisdiction. So, courts of limited jurisdiction, also known as inferior courts. While the court of unlimited jurisdiction, you can put in bracket superior courts. Now, let's look at definition of courts of limited jurisdiction. I'm sure even if we don't look at the definition, you already have an idea of what we're talking about, isn't it? Okay, but for what it's worth, courts of limited jurisdiction, also known as inferior courts, are courts that have restricted authority. Courts of limited jurisdiction are courts that have restricted authority and power to hear and decide cases. They are typically low-level courts. They are typically low-level courts that are authorized to handle specific types of cases. They are typically low-level courts that are authorized to handle specific cases. Such as 1. Minor criminal offenses. Minor what? Can you give me an example? Yes. Traffic violation and the likes. So, such as minor criminal offenses, small claims, that is civil claims involving limited amount of money. There are some people, if somebody owe you 10 naira, you must collect it at all costs. So, example is small claims. And the third example is family matter. Family matter that can include child support, child care, child custody, temporary custody anyway, and all of that. And the fourth example is local, or the one you call local or municipal matters. Local, let me pronounce it the way you are used to. Local or municipal matters. And this includes issue of noise complaints, zoning disputes, okay, zoning disputes or noise complaints, or the minor nuisance and all of that. So, examples of courts that have limited jurisdiction include the following. Examples of courts with limited jurisdiction include the following. Number 1, magistrate courts. Number 2, area courts. Number 3, customary courts. Number 4, small claims courts. Number 6, family courts. Number 1, magistrate courts. Number 2, area courts. Number 3, customary courts. Number 4, small claims courts. And number 5, are you right? Family courts. Now, what are the features of courts of limited jurisdiction? I want at least 2 solid features to show to me that you understand what we have been talking about all the while. Yes. What? They have restricted authority, yes. She already said what you wanted to say. I know, we are used to that. Yes? They are subject to review. Beautiful, yes?
The adjustment is not it's not strong.
Well, it's not, let's use the word not final. Yes? They have authority over minor cases, yes? You've changed your mind? They are what? Courts with limited authority. Any other person, yes? The guys are alive in this court, in this class. They are low level court, yes? They have limited geographical scope. Okay, that's beautiful. So I have it here that they are usually subject to the supervisory jurisdiction of High Court. Mind you, I hope you jotted all the answers they gave. All the answers they gave, they are correct. At least that one, those ones are coming from your colleagues, so it's easier to understand. So they are usually subject to supervisory jurisdiction of High Courts. They have jurisdiction over a specific area, such as a state, local government, or districts. They also have authority over cases involving limited amounts of money. I said they have jurisdiction over a specific area, such as a state, local government, or district. Number 3, they have authority over cases involving limited amounts of money. Number 4, they prioritize dispute resolution and settlements over complex legal arguments. They prioritize. Will I spell they prioritize? Prioritize. They prioritize dispute resolution and settlement over complex legal arguments. Number 5, they follow simplified rules. They follow simplified rules of evidence and procedure. They follow simplified rules of evidence and procedure, making it easier for litigants to represent themselves. So, what are the benefits of courts of limited jurisdiction? Number 1, benefits of courts of limited jurisdiction. Number 1, they provide easy access to justice for citizens, especially in rural areas. They provide easy access to justice for citizens, especially in rural or remote areas. Number 2, they are less formal and less expensive. They are less formal, less expensive, making justice very affordable. Because, of course, if you go to the Supreme Court, if you file an appeal now to the Supreme Court, as at today, you may not get a date until maybe 2027. What did I say? You may not get a date till when? I did not make a mistake. But if you file a case at the magistrate court today, give it maybe 2 weeks or less, it will be assigned to a court and a date will be given to you for you to come and tell your story. So therefore, if you are sending a lawyer to Supreme Court, you should be ready to pay his flight ticket, apart from his professional fees. But if you are sending a lawyer to Yaba Magistrate Court, then it's much less expensive. How many of you have visited the court since the last time we chatted on that? Nobody. You, that's good. Which court did you go to? What? The moot court. Why? I mean, okay. That's how did you get to know? Okay. You see, that's what we're saying. One way or the other, you will have learned something, isn't it? Yeah. So, just for you to give life to what we are teaching you. So, number 3, they handle cases quickly and efficiently. They handle cases quickly and efficiently. Number 4, they provide faster resolution of disputes, which is essential for commercial and business matters. They provide faster resolution of disputes, which is essential for commercial and business matters. Number 4. I've mentioned number 4. Number 5, dispute resolution and settlement is prioritized. That is another benefit. Dispute resolution and settlement is prioritized, promoting quicker and more amicable solutions. Then we have, lastly, on courts of limited jurisdiction, we have shortcomings of courts of limited jurisdiction. What do you think are their shortcomings? Yes. What can you say are the shortcomings of, yes, they have limited jurisdiction over a case, yes. Their shortcomings, they are what? Yes, their decision is not final. Okay, now let's look at it. They have limited authority to impose sentences and grant remedies. They have limited authority to impose sentences and grant remedies, which can limit their ability to provide justice. They have limited authority to impose sentences and grant remedies, which can limit their ability to provide justice. Number 2, they are restricted in the types of cases they can hear. They are restricted in types of cases they can hear, and monetary limits they can adjudicate. No, still on number 2, I'm explaining that. So, meaning that parties who have claims running to millions of naira above 10 million cannot, approach the court for it, simply because their powers cannot grant more than what is on paper. So that is another shortcoming. Number 3 is that decision made in this court may have limited option for appeal. Decisions made in this court may have limited option for appeal, potentially depriving parties of opportunities to have their cases reviewed by higher courts. Decision made in this court may have limited option for appeal, potentially depriving parties of the opportunity to have their case reviewed by higher courts if they believe an error has occurred. Number 4, because of the easy access to justice, they can be overwhelmed with cases. They can be what? Overwhelmed with cases. Another shortcoming is that judges in these courts may not have the necessary expertise to handle complex cases. Judges in these courts may not have the necessary expertise to handle complex cases. Complex cases. Now, let's look at courts of unlimited jurisdiction. If you've understood court of limited jurisdiction properly, you already have like 80% understanding of court of unlimited jurisdiction. Is that okay? Or do you agree? Do you agree? Okay, now let's take it on. Definition of courts of unlimited jurisdiction. Courts of unlimited jurisdiction are courts that do not have jurisdictional limits to any case. They are the type or the courts that do not have jurisdictional limits to any case, regardless of the type and the value of the subject matter. So they are typically higher level courts because they are courts of record. Okay, so, but note something here so that we don't get it all wrong. Typically in Nigeria, there is no court that really possesses unlimited jurisdiction. Is that not contradictory to what we have been saying all along? It's contradictory, right? But we still use the word unlimited jurisdiction for those courts, not because they can do anything, but simply because the limitations are very minimal. Do you understand? The limitations are what? Are very minimal. Unlike the court of limited jurisdiction that their own is compared to not having powers as such. Examples of unlimited jurisdiction courts are: number 1, Supreme Court of Nigeria, Court of Appeal, High Court of a State, the Federal High Court, High Court of Federal Capital Territory, and National Industrial Court. Supreme Court, Court of Appeal, High Court of a state, Federal High Court, High Court of the Federal Capital Territory, and the National Industrial Courts. What are the features of courts of unlimited jurisdiction? Features of courts of unlimited jurisdiction. Number one is that they have jurisdiction over the entire country or state and can hear cases from any location. The courts we are talking about here can hear any matter from any part of the state, meaning that they are not limited by a geographical area. Number two major features of the unlimited court is that they can hear cases involving any amount of money. Okay? So that is to say that there is no limit to their financial threshold. They can adjudicate on matters involving billions of naira, trillions of naira, as the case may be. Yes, you have a question?
Granted Emefiele bail and the money is over billions of naira. I have a question. Can the court, the bail they can grant the person, is the money limited?
No, and that's what we are saying, that they don't have limits over monetary threshold. It's also when it comes to bail, those conditions, they are just conditions. It doesn't mean that the person is supposed to come and pay it. Do you understand? They are just conditions to ensure that the person is present to attend to his cases. But they couldn't have taken Emefiele to a magistrate court, right? Because if the charges against him are established, the sum of money that is alleged to have that he has stolen, they are quite big. I'm sure you saw some pictures of some estates. How many of you saw the pictures of an estate? You saw the picture. And one thing that I know will have come to your mind is that, yes, tell me what came to your mind when you saw it. It will be sincere. I will tell you what came to my own mind. How can one person own this? Yes, who else saw it? There's somebody here who said, I wish you can just give me one of this. Because you just saw the way the thing just... So, imagine that alone, even one plot, the cost of a plot, not to talk of the building that is already on it, in that place is already beyond what a magistrate court can deal with. So basically, that really does not even form part of the judicial issue, but there are conditions attached to bail. No, number three, the decision of the Supreme Court as a court of unlimited jurisdiction in all cases is final and binding. The decision of the Supreme Court as one of the cases or one of the courts under this jurisdiction is binding and final. Number four, the decision of the Court of Appeal as a court of unlimited jurisdiction in certain matters are also final. The decision of the Court of Appeal in some cases are also final, meaning that you cannot appeal to the Supreme Court. I'm sure some of you are hearing that for the first time. There are some matters that must end at the Court of Appeal. Example include the national and state houses of assembly election matters. The right to appeal terminate at the court of appeal, meaning that for any matter relating to national and state houses of assembly election matters, it ends where? At court of appeal. Number 5, they have authority to grant any remedy. They have authority to grant any remedy or reliefs, including damages, injunctions, and also declarative reliefs. They have what? Yes. Injunctions and declarations. You know what an injunction is? You know what an injunction is? An injunction is an order of court forbidding an individual or a party from doing something. Let me simplify it like that. If the court should give Unilag an injunction against you that you should not enter the University of Lagos, is restricting your right of studentship has been stopped by that order. You cannot enter. If you enter, you'll be committing contempt of what? Contempt of what? Contempt of court. I spoke about contempt in the last class, where I was describing it as disobedience to court orders. Number 6. Okay, let's leave it at number 5. What are the benefits of courts of unlimited jurisdiction? Benefits of courts of unlimited jurisdiction. Number 1, they provide comprehensive justice. They provide comprehensive justice because they can attend or treat any kind of cases, that irrespective of whatever the subject matter is. They have comprehensive justice, or they provide comprehensive justice, so to speak. Number 2, due to the binding nature of their decisions, they provide certainty and closure for parties involved in a dispute. Due to their binding authority or nature, they provide certainty and closure for parties involved in a dispute. Unlike the inferior court or court of limited jurisdiction, where the fact that you have gotten judgment does not mean that is the end. They can go and do what? Go and appeal. I had a funny experience recently. We had a landlord and tenant dispute at the magistrate court, and we won. So we're planning that, we're happy that now that we have won the case, the man should carry his property and do what? And go. But you know what the man did? He went to the High Court and appealed. And the funniest thing is that once your judgment has been appealed against, what happens? What? Say it now. You are not starting again. You have to maintain status quo. You have to maintain and stop as if judgment has not been given in your favor. So we couldn't do anything to ask the man to leave the apartment, because he has already filed an appeal to the judgment. But of course, the appeal was done in bad faith. Somebody has been living in a house for 14 years and was paying 300,000 for an apartment that is worth over 1 million. and he does not want to leave. He went to the High Court and filed a case. By filing that case is like an appeal to the judgment that has been given at where? At the magistrate court. We could not do anything. And what they did was that they filed and left it there. They didn't follow it up. We were the one who went ahead, followed it up. We got dates when the court will hear the matter. They didn't even bother to come because they know that, of course, it's until they come that matter can make progress. But we did what we needed to do. Luckily, they gave us a date. They sent the date to us. They also sent the date for them. They didn't come to court. And it was my lord, the CJ of Lagos State, who presided over that case. And he was not happy that they did not come. Why? Because they were the one who filed. So meaning that their intention was to frustrate those of the party that has gotten judgment at the lower court. And my lord gave judgment that day, striking out their form of appeal. Don't let me bother you with the details. Meaning that the judgment of that lower court can be what? Can be executed. That was how we proceeded, went to the sheriff session, and then they gave us order to go and evacuate the man. We got to the house as early as 6:30. The man was still tying wrapper, enjoying himself. And of course, I told the sheriff officers that when we meet, the door has a gate outside, just like this door now. There's a gate. If you knock and the man opens and discover that it is people from court, the man will lock the door. He will never open again. That means he will quickly call his lawyer and say, what happened? I thought you said we have filed an appeal. These people are here. Then they can go to court that morning and go and file something. Then that may now keep us till thy kingdom come. So I already told those guys, I said, Oga, this man is not a man with human feeling. So we have to be careful of the way we deal with him. So I said, well, the children will go to school now, Abi. So he will open the gate at his own will. So we have to position ourselves strategically. I was praying. I said, God, don't let this man win us today. So at exactly around 7:30 something, they opened the gate and the son came out to go to school. That was how the sheriff entered the house. And once the sheriff had entered the house, he cannot do anything. Right there and there, he started carrying his things out. He was tying wrapper. We had to quickly go and wear and call his lawyer. His lawyer appeared less than 3 minutes. Maybe the man was living there. And the lawyer came, but we have filed something. We have thrown the thing away. That is the problem with the judgment of an inferior court. There's no certainty. Their plan was that appeal will remain there. And as long as it's there, the man is not paying any rent. His rent, you cannot increase it, and it will continue like that. That was how we evicted the man. He was shocked. I also remember a similar execution we did. The man just came out of the bathing room. You know, when you always come out of bathing room, your body is still wet and you cannot sweat, Abi. Immediately he knew that these people have come to throw away his things. The sweat that came out of his body was more than the water that was on his body. Okay, so let's move on. So I said, due to the binding nature of their decisions, they provide certainty and closure for parties involved in a dispute. I think I've mentioned that earlier. Okay. Okay, all right. So number 3, this should be number 3. Presence of expert judges to handle cases involving multiple parties. There is the presence of expert judges to handle cases involving multiple parties, complex legal issues, and huge sum of money. Presence of expert judges to handle cases involving multiple parties, complex legal issues, and huge sum of money. So that story that I told you is to the stubborn tenants who wants to inherit the own house of a landlord. Your own day of judgment will come, and you cannot appeal against it. Before you can even appeal, they will have throw your things outside, and the neighbor will be laughing at you. The man was looking for where to put his children. I understand that even the people living in the same block, they could not accommodate him in the night. When we were bringing out his things, rain started doing as if it wants to fall. You see how judgment of God can also add to judgment that God has given. Because the small things that he has, even the bed, the mattress, it may even be difficult for you to touch it. Rain will now still fall on it. You see how? So those of you that are doing evil, repent. Because judgment will come. Alright, so number 4 is that they can efficiently resolve complex cases. And number 5 is that they play critical role in upholding the rule of law. The higher courts, the courts of unlimited jurisdiction, play critical role in upholding the rule of law. Okay? They help in upholding the rule of law. The last way we are going to talk about briefly before we bring the class to a close, we include shortcomings of courts of unlimited jurisdiction. I hope my attendance is ready. Shortcomings of courts of unlimited jurisdiction. Number 1, litigation in courts of unlimited jurisdiction can be expensive. You cannot spell litigation. I was fast. Okay, spell litigation for me. Even though I don't know it too, they are also helping you to echo it. Litigation in courts of unlimited jurisdiction can be expensive, as cases often require complex legal representation. Litigation in courts of unlimited jurisdiction can be expensive, as cases often require complex legal representation. Now, let me tell you what we mean. Let's say, for example, you have a case. You have a question? Yeah, let me explain this first. Take, for example, you have a case at the Supreme Court. In my faculty, by the grace of God, we have people that you can, when you are looking for experts on fields in this country, they are there. Some of them, their own is expertise is on energy law. Some is on evidence. Some is on, they have expertise in land and all of those things. So when you have a case in that Supreme Court, and there are the aspect of it relates to criminal law, aspect relates to civil aspect. Of course, every of those aspects we need evidence, expert in evidence. So you may need to go and get a senior advocate of Nigeria who is an expert in cross-examination, in evidence prosecution generally. You need to get experts in land matter, that his own area is that. And to hire a senior advocate of Nigeria is not small money. So those who carry on cases, when you see the election tribunals happening, you see about 20 SAN representing one person. You know the reason when they say they are preparing for election, you see the rate at which our money disappears, because they are preparing for the aftermath of the election. They are ready to pay you. When one of my ogas was saying that a particular party was owing him 200 and something million, yes, as his professional fee. I said 200 and something million, you say ha. Me too, I will say ha now, because that's a lot of money. That's one major issue with Court of Unlimited Jurisdiction. The representation will require a lot. It's not for people like us who are saying ha. Let me take your question now. Yes. Yes.
You mentioned Federal High Court and High Court of the FCT. What is the difference?
Okay. Federal High Court is a distinct court. High Court of Federal Capital Territory is also a distinct court. FCT is not a state, but it's on its own by virtue of it being the capital city of Nigeria. So the law provided its own high court, which share the same jurisdiction with the state high court. In that regard, the High Court of FCT is treated like that with state high court like Lagos State, Ogun State, and so on. Then Federal High Court is a special court created to handle some matters. Number one, they deal with cases relating to maritime. Maybe all those shipping that you see, contracts relating to shipping, some issues like financial fraud or crimes and all of that. It's a special court, just the way we have National Industrial Court. National Industrial Court is created to handle labor matters. Labor matters in the sense that if your employer, if there's a disagreement between an employer and employee, do you understand? So Federal High Court is different from State High Court or Federal High Court of Federal Capital Territory. Do you understand now? So the High Court of Federal Capital Territory is just like High Court of a state. Good. Yes, please.
Litigation in this court can be expensive as cases often require complex law representation.
Yes.
So you said that the parties will pay maybe each legal representation, their fee.
Yeah.
So is it that they are also going to pay the cost, and like where the money goes?
Okay, they don't pay. The money you spend in filing those things are very minimal. If you are filing a case now that involves like 50 million naira, the entire money you will spend in court may not be up to 50,000 to file it.
So what's 50 million naira now?
Is to prepare that thing that you file, to prepare that document requires a lot. Then the expertise that will be displayed in handling the matter is also what you are paying for. I'm a lawyer, but someone who is a senior advocate of Nigeria, a son, and myself, we don't have the same knowledge, right? He has been there for many years, even before I went to school or before I graduated. So the level of knowledge cannot be the same. So we cannot be paying for the same thing. Do you understand? All right. So that was the last point I made. Okay, number two, they are not infallible and they make errors in their decisions. They are not infallible. Infallible is spelled INFALLIBLE. They are not infallible and they make errors in their judgments. Number 3, they can be swamped with cases. They can be swamped with cases leading to delays, which can deny parties timely justice. Okay? So, of course, when they do not have all the time to attend to all the cases, it's, of course, delay the turnaround time within which they are supposed to deliver their judgment, and consequently, judgment will also be delayed. But a delayed judgment is not a denial. Okay? Yes, you have a question? Which can lead to, which can deny parties timely justice. That's what I said. It can deny party timely justice, but justice will still come. Because the parties also, the court is also open to all the litigants. So when you file your case, they will treat it the way they will treat others. So there will be delay. We are taking everything turn by turn. Yes. Swagalicious, Abi Flagamonia. Which one? What did they write there? Yes. If you have, yes. Yeah. Realize mistake. Yes. About what you have appealed again. What kind of mistake?
Okay, so let's say there's this like grandmother now,
yeah.
And this person is grandfather, this is grandfather. Yeah. They do this arrangement, and they not discover that okay, some money was given and some recorded and something like that.
Yeah.
And then they already decided that okay, this one belongs to this family.
Yes.
So like now, how will they approve and this is because I cannot approve.
And the judgment of the court will still be final. If yes, it will be final. If the mistake is not from the court, because I'm trying to understand where you think the mistake is from.
If the mistake is not from the court, what's now?
And that's the end. Yes. That's why we have said it there, that they are not infallible, meaning that they can make mistake. The fact that they are court of one limited division, they are powerful, they are knowledgeable, does not mean that they cannot make mistake. It's only God that cannot make mistake. If they realize their mistake before they pass judgment, they will correct themselves. It's a court of justice. After they pass the judgment, hold it on here. Number 4. They often have complex procedure and formalities. They often have complex procedure and formalities. They often have complex procedure and formalities which can be intimidating to non-lawyer to participate. They often have complex procedure and formalities which can be intimidating for non-lawyers to participate. And lastly, they may be located in distant locations. They may be located in distant locations, making it difficult for parties from remote areas to access justice. For example, the Supreme Court of Nigeria is located where? Abuja. So if you have a case, you are a resident in Lagos, and you have a case in Abuja, is either you fly there, or you walk there, or you enter Ekele Dilichukwu at night, whichever way. Is different from if you are living in Unilag, and you have a case at Yaba Magistrate Court. You can trek, you can walk there, isn't it? All right, so With that, we have come to the end of the topic with the research limited and court of limited and unlimited jurisdiction. And I believe that we've done justice to it together. So I expect that you do further reading for you to have more understanding about it. So thank you very much. We call it a day here.